Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the I-601 waiver. The I-601 waiver is utilized by those who've had a finding of inadmissibility for entry to the United States. Usually this occurs in the adjudication for a visa during the visa application process. We've dealt with it quite frequently here through the U.S. Embassy in Bangkok, specifically their consular section where they're adjudicating visa applications. Where a finding of inadmissibility exists, it may be possible, and I stress may, depending on the circumstances, it may be possible to obtain an I-601 waiver of said inadmissibility. And if the I-601 waiver is approved, it may be possible to go ahead and get a visa issued notwithstanding the existence of a finding of inadmissibility. So, how long does that process take? Well, the short answer is it's circumstantially dependent. It's going to heavily depend on what, in my opinion, what ground of inadmissibility is at play. For example, there are some more routine grounds of inadmissibility that I think are dealt with much more frequently than others, and for that reason, there's kind of a, for lack of a better term, sort of a routine aspect to how they're processed. Right now, I'm thinking of overstay bars, those who have overstayed in the United States by statutorily requisite periods of time, which then trigger a mechanism whereby they're barred from re-entering for a certain period of time. It is possible to get an I-601 waiver of such an inadmissibility. In those cases, I think those cases are treated a little bit more routinely. Now, compare that to one of the few types of drug violations that may be remedied through a waiver, or compare that to something like a crime involving moral turpitude adjudication, things of that nature, prostitution waiver, for example. These are more non-routine, for lack of a better term, non-routine types of waivers. And for that, and they're also very circumstantially dependent. So it's going to require the adjudicating officer make findings of fact and conclusions of law based on situations which are very dissimilar from one another. It's not simply making a finding of fact and a conclusion of law based on a certain period of time and whether or not that met a certain threshold, and then adjudicating whether or not the circumstances in the case warrant a finding of extreme hardship and thus an issuance of an I-601 waiver. For example, things like crimes involving moral turpitude, the nature of the crime probably comes into the adjudication, the specific circumstances of the qualifying relative, how extreme hardship plays into all of that. It's going to be very, very dependent on the circumstances. That being said, I think it's very safe to assume you're looking at least months, possibly over a year before receiving a final decision with respect to an I-601 waiver. Another thing to take away from this video is it also probably depends on how it processes through. Is there an RFE, a request for evidence issued, or notice of intention to deny? Where a case might be denied, does a motion to reopen have to be filed, or an appeal? Sometimes these have to be added on to the I-601 process, and that can cause, in the aggregate, you can have a lot of time expended waiting out the processing of the I-601 petition. So the thing to take away from this video is the I-601 waiver, it's a really serious adjudication. It's rather serious lawyering. Making one's case that a qualifying relative would suffer an extreme hardship. Specifically, there are other ways of possibly getting an I-601 waiver issued, but that one specifically, that can be a really high threshold to overcome. The thing to take away from this video is it's hard to say exactly how long that's going to take. I think it's safe to assume, months, possibly over a year, before a final decision is reached with respect to an I-601 waiver.